Good morning, I'm Gary DeWaal, and this is Bridging the Week for April 10th to 14th, and today is April 17th, 2017. Two employees of unrelated trading firms were criminally charged in a federal court in New York City with either stealing or trying to steal source code of their employer's proprietary trading platforms. Separately, a broker-dealer and its principal, accused last month by the Securities and Exchange Commission of aiding and abetting a client's purported ongoing manipulative trading, vehemently disputed such allegations and said that its customers' trading represented ordinary market activity. International developments made the world seem a little crazy last week, so we can calm down and concentrate just on some significant developments in the financial services industry. Let's get started. One former employee of Susquehanna International Group and another from KCG Holdings were criminally charged in a New York federal court with offenses related to the alleged theft of trade secrets from their former employers. In one action, Dmitry Sazonov was criminally charged for his alleged attempted theft of proprietary computer code for a Susquehanna trading platform, while in the other, Zhequan Zhang was criminally charged for his alleged theft of proprietary computer code regarding algorithmic models and trading platforms of KCG. Both cases were initiated by the U.S. Attorney's Office for the Southern District of New York. According to the complaint against him, Mr. Sazonov was employed as a software engineer. After he learned that a fellow employee had left Susquehanna on February 3rd, Mr. Sazonov purportedly took steps to convert Susquehanna proprietary source code to PDF format and then to append separate pieces of the newly created PDF file to innocuous documents and files on his firm's desktop computer. Mr. Zhang, a technician employed by KCG from March 2010 through March 2017, was alleged to have stolen proprietary source code and transferred it to an external third-party development site, and also remotely, without permission, to have accessed the computer desktops of other KCG employees. If convicted, both Mr. Sazonov and Mr. Zhang could be subject to imprisonment up to 10 years and a fine of $250,000 US. I expressed some of my thoughts on this case and the proposal of the Commodity Futures Trading Commission and Regulation Automated Trading that persons subject to the regulation might have to turn over source code to the CFTC and Department of Justice without subpoena on the article version of Bridging the Week on the website. Check it out. Lek Securities Corporation, a broker-dealer, and Samuel Lek, the firm's principal owner and chief executive officer, vehemently opposed the motion of the Securities and Exchange Commission filed in March in a federal court in New York seeking a preliminary injunction against them for their role in allowing a customer, Avalon FA Ltd., to engage in purported manipulative trading activity through it. Separately, Avalon also filed papers opposing the entry of a preliminary injunction against it. In its original complaint, the SEC charged that Avalon engaged in two types of manipulative conduct: layering and cross-market manipulation involving equities and related options from December 2010 through at least September 2016. The SEC alleged that Lek Securities and Mr. Lek were aware of Avalon's improper activities when, among other things, Mr. Lek received an email in May 2012 explicitly describing the layering scheme from an individual who shortly afterward became an Avalon Trade Group leader, as well as when regulators, exchanges, and other market participants alerted Lek Securities and Mr. Lek on various occasions from 2012 to 2016 that they were concerned that Avalon was engaging in layering. In its opposition to the SEC's motion, Lek Securities and Mr. Lek denied any wrongdoing and claimed that the brokerage firm maintained a, quote, robust program, end of quote, to prevent layering by any of its clients, including Avalon. Lek Securities, Mr. Lek, and Avalon all claimed that Avalon's alleged spoofing orders were legitimate and disseminated no false information to the market. Late last month, Lek Securities and Mr. Lek were also charged in disciplinary proceedings by the Financial Industry Regulatory Authority and 10 exchanges with aiding and abetting the alleged manipulative trading of Avalon, as well as other violations. And finally, FSC Securities Corporation, a Securities and Exchange Commission registered broker-dealer, agreed to pay a fine of $200,000 to resolve a disciplinary action brought by the Financial Industry Regulatory Authority, claiming that it failed to maintain adequate supervisory controls related to the payment of customers' funds to non-approved third parties. Specifically, FINRA alleged that from March 2009 through April 2010, FSC authorized payments to a bank account controlled by PFG LLC, an investment fund created by a former employee of FSC. A then current employee of FSC recommended the PFG fund to his clients even though it was not approved by FSC and he received a percentage of the management fees generated by the fund. Ultimately, the PFG fund lost, quote-unquote, millions of dollars, and the customers who invested in the fund suffered, quote, significant losses, end of quote, said FINRA. FINRA claimed that FSC did not have systems or controls to monitor for a pattern of payment from multiple clients to a single third party. Unrelatedly, as has now occurred on multiple prior recent occasions, the Hong Kong Securities and Futures Commission, resolved a disciplinary action against the licensed HK brokerage firm for failure to have adequate safeguards to prevent the risks of money laundering associated with third-party deposits and transfers. In this action, the Securities and Futures Commission claimed that iStar International Futures Co. accepted third-party deposits on behalf of clients without appropriate documentation and, in one instance, permitted a payment from a client's account to the account of one of iStar's own officers. iStar agreed to pay a fine of 3 million Hong Kong dollars, or approximately $386,000 US dollars, to resolve this matter. Well, that's it for today. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal, and until next week, have a great week, and ciao!